Hello, and this is the second lecture for topic 8. And in this lecture, we're going to be taking a look at the Supreme Court and its main power, the power of judicial review. So what are we going to be covering in this lecture? Well, first, we're going to take a look at the role that the United States Constitution plays in establishing the federal judiciary. Next, we're going to look at how Supreme Court justices are selected and the session of the Supreme Court. We'll also take a look at the Supreme Court process and take a look at the current court, which is known as the Roberts Court. And then we'll move on and we'll talk about the power of judicial review. This will define what judicial review is, and we'll talk about where the Supreme Court gets its judicial review. And it's from the famous case Marbury versus Madison. And so that's what we're going to be covering in the lecture. Let's go ahead and get started. So when you think about the United States Supreme Court, what comes to mind? When you hear those words, U.S. Supreme Court, what comes to mind? I mean, I think a lot of people these days, when you think about the United States Supreme Court, they might really think about it as being very politicized, that it's a political court, that it's polarized, that there are a lot of 5-4 decisions, and that a lot of people sort of think that the Supreme Court makes decisions maybe not based on proper constitutional interpretation, but they make decisions based on their ideology. Whether that's true or not, I think that is the perception that a lot of people have of the court. And in fact, our current Chief Justice John Roberts, he's actually concerned about the legitimacy of the court too, because he gets a sense that people think that it is highly politicized, and therefore he's wondering whether or not people really trust the court's authority or see it as a legitimate institution. So if that's what came to mind when I put that up there, you're not alone, because that's something that the Chief Justice is thinking about as well. What do you know about the Supreme Court? Do you know how many justices sit on the Supreme Court? Do you know how justices get selected to serve? Do you know if there's any qualifications to be a Supreme Court justice? Do you know how long their term of office is? And do you know what kind of cases the Supreme Court hears? Now, you might know a little bit more about that because of our previous lecture, but we'll be learning more about that as we move on today. I want to encourage you again to watch the Vox video. We are going to be talking about how a case kind of gets to the Supreme Court and what happens once a case gets to the Supreme Court. But the Vox video in a really short period of time does a great job in terms of talking about the kinds of cases that the court hears. So make sure that you watch that short video. Also, you're going to be reading an article for this week. It's by Norm Ornstein. And it's an article about term limits, instituting term limits for the Supreme Court. Now, the appointment to the Supreme Court is a lifetime appointment. The appointment to if you're of any federal judge, not just the Supreme Court, but any federal judge, it's a lifetime appointment. But some think that we might be benefited from changing our Constitution and having a term limit on Supreme Court justices. And so make sure that you read Norm Ornstein's article, because it presents a really provocative idea about term limits and the impact that it might have on decreasing the temperature or the politicalization of the court. Okay, so just as we learned that the Article 1 of the Constitution establishes the Congress and Article 2 of the Constitution establishes the presidency, it's Article 3 of the Constitution that establishes the federal judiciary. So what does Article 3 say? Well, one of the things that it says is that judicial power of the United States shall be vested in one Supreme Court. And so keep in mind, just like with the presidency, remember there was no presidency in the Articles of Confederation. So Article 2 created a new branch of government. Well, Article 3 also creates a new branch of government, because under the Articles of Confederation, there was no federal Supreme Court. There were no federal courts. So this is a new branch of government that's created under the Constitution. That when you say that judicial power of the Supreme Court judicial power of the United States shall be vested in one Supreme Court, what does that mean? Well, what that means is that the Supreme Court hears cases that deal with federal law and cases that deal with the Constitution, and so that if a case is just a matter of state law and it doesn't have any implications for the Constitution, then the Supreme Court doesn't have the jurisdiction, it doesn't have the authority to hear that case. And so it is really limited to federal law, the Constitution. They can also hear cases about treaties, and they can also hear cases that are disputes between two states. And so the authority or the jurisdiction of the Supreme Court is also outlined in Article 3. Another thing that the Constitution tells us is that there are some times that the Supreme Court can actually act as a trial court. In other words, there are some times when the Supreme Court can hear a case for the first time. That means that it has original jurisdiction. But there are not a lot of cases. There's very few times when the Supreme Court acts as a trial court. For the most part, it acts as an appellate court. It hears cases not for the first time, but it hears them upon review. The size of the Supreme Court is not established in the Constitution. In fact, the only reference to the actual justices in the Supreme Court is the Constitution does make reference to the Chief Justice. And it doesn't make reference to the Chief Justice in Article 3, but it makes reference to the Chief Justice in Article 1, Section 3. And it's in Article 1, remember that the Congress has the power to impeach and remove a president. And so it's there where it says that the Chief Justice will preside over the trial for removal. And so the thinking is, well, there will be a Chief Justice, so that means that there's got to be associate justices as well. But the size isn't in the Constitution. It doesn't say 9, it doesn't say 3. The size of the number of justices that serve on the Supreme Court is set by Congress, not the Constitution. It's varied over time, but it's been 9 since 1869. And so it's been 9 Supreme Court justices for a while. We could increase the size of the court. During the campaign in 2020, that was, something that, because the court seems to be getting really politicized, some liberals are wanting to have a Congress and also a president that's willing to expand the size of the court because they feel that liberal voices are not getting enough representation on the court. That's not something that Biden or the Congress is approving or pursuing, but they could change the size of the court if they wanted to. So right now there's 1 Chief Justice and 8 associate justices. But another thing that Article 3 does, and that's by congressional law, the total of 9. The other thing that Article 3 tells us is that there will be lower federal courts, but that Congress is responsible for establishing what the Constitution says are the inferior courts. And so those U.S. district courts we looked at in the last lecture and the U.S. Court of Appeals, the fact that there are 94 and 13 circuits, that is not in the Constitution. And in fact, that authority is given to Congress to establish those lower courts. And Congress also sets the jurisdiction of the lower inferior courts as well. So that's a quick overview of what Article 3 tells us about the Supreme Court. Okay, so let's turn our sights to the selection and service of the justices on both the Supreme Court, but also to the lower federal courts as well. So there are judges that serve in the U.S. district courts, and there are judges that serve on the U.S. Court of Appeals, and then there are obviously judges that serve on the Supreme Court. And so a lot of times when we think about federal judges, we only think about the 9 judges that serve on the Supreme Court. But there are many, many more federal judges that work within the federal judiciary. But regardless of whether you're a federal judge at a district court and a lower appellate court or on the Supreme Court, the same process for selection applies. And so that, as we learned in last week, that one of the functions of the President of the United States is to serve as the chief executive officer, right? The CEO. And as CEO, they have executive power. And one of the executive powers that they have is to select people who are going to be serving within both the executive branch, but also in the federal courts as well. And so federal judges are nominated by the President of the United States, but then Senate needs to confirm those nominations. It used to take, because of the filibuster, it used to take 60 justices to confirm federal judges, but that is no longer the case. The Senate changed its rules, and so all you need is 51 senators to confirm justices to the federal bench. That oftentimes for the Supreme Court, that nomination and confirmation process is really heated and it gets a lot of attention. But the nomination and a confirmation of the lower federal court justices don't usually get a lot of attention. The reason that the president nominates somebody to the federal bench is because that there is a vacancy. And so that vacancy could either come through death. And so, for example, Ruth Bader Ginsburg, Associate Justice Ruth Bader Ginsburg, died last year in September of 2020. And because it was a vacancy due to death, then President Trump nominated Amy Coney Barrett to replace Ruth Bader Ginsburg. And she was confirmed, obviously, by the Senate. But oftentimes, the vacancy doesn't come as a result of death, but it will come due to just a justice retiring. Right now, liberals are angry that one of the older justices on the bench, Associate Justice Breyer, that they want him to step down because they want President Joe Biden, to replace Justice Breyer, because Justice Breyer is a liberal judge. But despite his age, Justice Breyer, much like Justice Ginsburg, said, nope, we're going to serve until we don't want to serve anymore. So we'll see what happens with that in the future. As we know, or as you will know from reading the textbook, that all federal justices serve a lifetime appointment. And so they serve until they don't want to serve anymore. But justices can be impeached. And so the impeachment provision within our Constitution says that civil officers can be impeached, and that includes justices. That there haven't been a lot of impeachments of federal justices in history, just as there haven't been a lot of impeachments of presidents, but it has happened. There is no constitutional qualification to be a chief justice of or a federal judge. However, that there are generally some, while there aren't constitutional qualifications, that there are norms in terms of qualifications. And so usually people who serve on the federal bench have went to some of the best law schools in the United States. Those who serve on the Supreme Court usually have served as appellate justices in the Circuit Court of Appeals and the U.S. Court of Appeals. And so while there are no constitutional requirements, there are norms in terms of qualifications that are followed. And if you don't have those qualifications, the chances of you getting confirmed by the Senate are not very high. The Supreme Court has a particular session. It starts on the first Monday of October. So the new Supreme Court session just, started about a month ago, and it goes until the end of June. Now, because of pandemic, that the 2020 session went longer than June. It went into the summer. That is, again, just a norm of the court. It's not in the Constitution. If you want to learn more about the Supreme Court, there's a great book you could take a look at called The Most Dangerous Branch. The framers thought that the Supreme Court would be the least dangerous branch because it would not really get involved in its, judges aren't elected, they're nominated and confirmed, and that the power that they had, they viewed as sort of not, limited, very limited. But that's really changed. And so this is a book that kind of looks at sort of the extreme power that the Supreme Court, and maybe too much power. We read that book in my civil liberties class. So if you take the class, you'd read that, but otherwise just pick it up. It's really reader friendly. And you get to see behind the scenes of the Supreme Court, which is really interesting. Also, if you're you're like a Supreme Court nerd like I am, you might want to take a look at SCOTUS blog. SCOTUS stands for the Supreme Court of the United States, SCOTUS. And, a lot of big rulings come out at the end of the Supreme Court's term in June. And SCOTUS blog will live blog the release of decisions. And it's really exciting. You get up at 9 o'clock, you get on your computer, and you basically watch and wait for landmark cases to come down the pike. So if you want to learn more about the Supreme Court and be on the cutting edge of what's happening with the Supreme Court, check out SCOTUS blog. It's really interesting. Okay, so this is a picture of the current justices on the Supreme Court. They actually take a school photo, basically, not at the beginning of each Supreme Court term, but when there are additions. And the newest addition to the court is up here in the, I don't know, what is that, the right-hand corner, Amy Coney Barrett. So they took a new picture recently, and so there it is. It's called the Roberts Court because John Roberts, and so where is John Roberts? John Roberts is obviously right in the center since he's the Chief Justice. He's the Chief Justice of the Supreme Court, and so that when we get a new Chief Justice, we kind of rename the court, and it's known as the Roberts Court. Prior to that, it was the Rehnquist Court. Like one of probably the most influential courts in terms of civil liberties was the Earl Warren Court, the Warren Court, that really expanded civil liberties in the United States. And so it'll be the Roberts Court until Chief Justice John Roberts decides to step down, and hopefully, heaven forbid, that he would die in office. Let me put my magic pen on again. These three are the newest members to the court. And so this is Neil Gorsuch. He was the first appointee from the President Trump. This is Justice Kavanaugh, Brett Kavanaugh. His nomination and confirmation was very, very contentious because there were accusations that he engaged in sexual assault. And then the newest member of the court is Justice Amy Coney Barrett. And she joined, as I mentioned before, in 2020. As the least senior member of the court, she actually gets coffee for the other justices. I'm not making that up until a new justice adds. Going from the longest member that's been on the court the longest, this is Clarence Thomas, Justice Clarence Thomas, and then it's Breyer, and then here is Sam Alito, and then these are the two appointees from Obama. This is Elena Kagan, and this is Justice Sonia Sotomayor. Okay, Clarence Thomas was appointed by the first Bush, H.W. Bush, and then Alito and John Roberts were appointed by the second Bush, George W. Bush. So that's just a picture of the Supreme Court. And here is just a graph of the Supreme Court, and I'll let you take a look at this on your own time. But on the side here is obviously the names of the Supreme Court justices, their age, what their experience is, and then also the president that appointed them. And I start with John Roberts is on top because he has the greatest seniority because he is the Chief Justice, but he hasn't been on the court the longest. In fact, Clarence Thomas was appointed, he's the most senior member on the court. He doesn't have the highest seniority. The Chief Justice has more power than the associate justices, but that he's served on the court the longest since 1991. The reason that, the Chief Justice does not have to be selected from the associate justices, that he was appointed to the Supreme Court as Chief Justice of the United States. But other Chief Justices have been moved up from their associate's position. And then this just sort of shows you the breakdown. So I encourage you to take a look at this because it'll give you some more information about the court. Okay, the last thing we're going to take a look at before we look at the powers of the Supreme Court, that is the power of judicial review, I just want to do a quick overview about the Supreme Court process. There are more details of this in the chapter, but I just wanted to give a quick overview so that as you're reading it in the chapter, it's easier to follow. Okay, so the first thing, and I mentioned this in the previous slide, is that the Supreme Court doesn't have an obligation to hear cases. The Supreme Court has the discretion as to whether or not it's going to hear a case on a review, okay, exercising its appellate jurisdiction. And so with the lower appellate courts, everybody gets a right to have one review. They have a right to have to appeal their case one time. They don't have to exercise that right, but they can. But you don't have a right for the Supreme Court to hear your case. They have discretion. And as you'll see in the Vox video, thousands of petitions are made to the Supreme Court every year asking the Supreme Court to review their case for the final time. And only a handful, about 100 cases are granted review. And when the Supreme Court says, you know what, we're going to hear your case, we're going to give a final review, appellate review of this case, they issue what's known as a writ of certiorari. Okay, it's also known as just cert. And so that if you petition the Supreme Court to hear your case, and they say, yep, we're going to hear your case, they then issue a writ of certiorari. It basically means we're going to hear your case. Once cert is granted, then it triggers a whole bunch of other things. And so once cert is granted, and then what happens is that lawyers for each side of the case, they submit briefs to the Supreme Court, making the argument about like why a law is unconstitutional or why a law is not unconstitutional, right? And so you have both sides that will submit briefs to the court, basically telling them why they think the court should rule in their favor. Also, people other than the lawyers that are representing the plaintiffs in the case, other people can submit briefs to the court as well, and they're known as amicus brief or amicus curiae briefs. And basically, what an amicus brief is it's a friend of the court brief. And so those written briefs can also be submitted to the Supreme Court, encouraging the Supreme Court to rule one way or the other. So for a concrete example, let's say that there is a case having to do with the Establishment Clause, like whether or not putting a big granite monument of the Ten Commandments in a state-owned park, whether or not that violates the Establishment Clause. Well, groups that are affiliated with promoting religious liberties and making sure that people's religious viewpoints are expressed, have that opportunity, they're going to submit briefs to the court saying, nope, this isn't a violation of the Establishment Clause. But other groups like the American Civil Liberties Union, they will submit briefs saying, yes, 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 this is a violation of the Establishment Clause. And the justices read those briefs. Actually, their clerks read those briefs, but they read them too in terms of getting prepared for the next step. And so once briefs are submitted, then the court hears what's known as oral arguments. And they're called oral arguments because they are actual arguments that are made in person to the Supreme Court. There were just oral arguments yesterday for asking the question about whether or not the Supreme Court has the jurisdiction to sort of hear that case, the Texas case, having to do with that you can only get an abortion, that you can't get an abortion after 6 weeks of being pregnant. So there are a long time. Usually in oral arguments, each side only gets a half an hour. But yesterday, the oral arguments went on for, I think, nearly 2 hours. I listened to part of them. They were very fascinating. And so they hear these oral arguments to ask questions about the briefs that were submitted. And it used to be that the oral arguments were recorded, but they were released to the public later on. But thanks to the pandemic, upside of the pandemic, that you can actually listen to oral arguments in real time. During the pandemic, the justices didn't even go to the court, and the oral arguments were done during phone, and you could phone, not Zoom, but like phone calls, and you could listen in, and those were fun, but not that much fun. Now they're back in the court, and they're actually making oral arguments in person. Spectators are not allowed in the Supreme Court right now, but the justices and the lawyers are. But you can listen to those. They're broadcast real time, which might not seem like a big deal, but it's made it's a significant change for the Supreme Court that is really resistant to sort of opening its doors to public purview. After the oral arguments, then the court gets together, the 9 justices, and they decide how they're going to rule in the case. And you'll read more about the details of that in your textbook. And then after they decide how they're going to rule in the case, then different judges are assigned the opinions that they're going to write. And so the court writes and publicly releases the decision of the courts and of the Supreme Court. And so in the textbook, that the opinion of the court, it reflects what the majority of the court wants. It's sometimes referred to as the majority opinion, and that's basically the ruling of the court. But then those who disagreed with how the majority ruled, they can submit dissenting opinions. And if you agree with the decision of the court, but you don't share the same reasoning that the majority had, you can submit a concurring opinion. And these are publicly released, and you can read them. That decision of the court is the final decision of the Supreme Court, but unless we can amend the Constitution to override the decision of the Supreme Court. So, for example, if the Supreme Court decides to overturn Roe v. Wade, we could amend our Constitution to say that there is a right to privacy in the Constitution. That's not likely to happen, but it could happen. Or there could be a new court ruling, okay? So sticking with the Roe v. Wade decision, that Roe v. Wade says that women have a constitutional right, or pregnant people have a constitutional right to an abortion. It could very well be that Roe v. Wade is going to be overturned in this court session. And so that that decision, stare decisis, it stood until a new decision that the court could make. The court always says it's going to stand by settled law and respect stare decisis, but it doesn't always do that. Okay, the last thing we're going to talk about is the power of the Supreme Court. And the power of the Supreme Court, the power of judicial review. So what is judicial review? Well, judicial review is basically that the Supreme Court can invalidate actions of Congress, the executive branch, or the actions of state or local governments as well, if those actions, if those laws are deemed unconstitutional. That's what the power of judicial review is, and it's one of the most important powers that the Supreme Court has. Basically, judicial review gives the Supreme Court the power to nullify state laws and to nullify federal laws and local laws as well that it deems to be unconstitutional. This is a power that is not actually enumerated in the Constitution. It's not explicitly stated. It is a power that is derived from the powers that are outlined in Article 3. And it's in the landmark case, which we're going to talk about in a moment, Marbury versus Madison from 1803. It's in this case that the power of judicial review was established. Now, you might be saying, hey, crazy Professor Hankinson, what's with the lame duck? See, it's a duck and it's lame. It has a little crutch on its leg or something, a little cast on its leg. Poor duck. What the heck is that lame duck doing up there? Well, a lame duck is basically when a president has a run for re-election and they lose their effort at re-election. And they don't leave office immediately, but they're there for some time. And they're known as a lame duck president. Congress can also be a lame duck Congress. Basically, if Congress was in the hands of one party and then the people who ran for re-election lost their re-election and a new party comes to have the majority in Congress, there's a period of time, like today it's from November until January. Back in the day, it used to be from November until March. And so there's this time period when Congress and the presidency can be lame ducks, and they can do things that like extend their power as far as possible. And Marbury versus Madison is a product of the lame duck Federalist court packing that went on. And so let's talk about that in the case details of Marbury versus Madison. Okay, so what's going on with Marbury versus Madison, and why is it such an important case? Well, in order to understand Marbury versus Madison, you need to understand some historical background. And you also have to know who some of the key players are. So one of the key players in Marbury versus Madison is John Adams. And he is the president up until 1801. And the other key player is Thomas Jefferson. And now, what's important about John Adams and Thomas Jefferson? Well, one thing you should know about the United States is that until the late part of the 1790s, there were political parties in the United States like we have today. Democrats, Republican, red, blue, it's very polarized. It wasn't like that at the founding. In fact, that was looked down upon, this idea that you would be associated with a party. However, when George Washington steps down, he serves his 2 terms in the presidency. When he steps down, parties begin to develop. And the person who develops the first party basically is Thomas Jefferson, because he wants to rival those who follow in the footsteps of George Washington, the so-called Federalist Party. And so Thomas Jefferson creates a political party called the Democratic Republicans. And he runs against John Adams in 1796. John Adams is a Federalist, Thomas Jefferson is a Democratic Republican, and he loses. And so the election in 1800 is a reboot of that match between John Adams and Thomas Jefferson. And this time, the Democratic Republican Thomas Jefferson wins. And so it's this huge moment in American history because we have this peaceful, and it was peaceful, transfer of power from the Federalist to this new party, the Democratic Republicans. But John Adams and the Federalists, they weren't going like quietly into the sunset. John Adams and the Congress, the Federalist Congress, were lame ducks. They lost election, but they still had some time to do some mischief, and they did some mischief. And what John Adams and the Federalist Congress did is they were like, you know what? We have the power to create new federal courts. And so, gosh darn it, we're going to create new federal courts, and we're going to pack them with a bunch of Federalist judges. Take that, Thomas Jefferson and you damn Democratic Republicans. And that's exactly what they did. They created a bunch of new federal courts, and they packed those with Federalist judges. When Thomas Jefferson and his Secretary of State, also Democratic Republican James Madison, when they actually took office and they entered into their offices, they saw that there were a bunch of commissions that were left out that never got delivered to these federal judges. So to actually become a federal judge, you just don't get anointed like you are now a federal judge. There's actual legal document that's delivered to you and you accept it, and that's when you become a federal judge. And so when Thomas Jefferson and James Madison took office, they're like, shit, man, we ain't delivering these damn commissions to those damn Federalist judges that they forgot to deliver them. We're not going to do it on their behalf. And that's what they did. They refused to deliver commissions to those who had been duly nominated and confirmed by the Federalist Congress. And that's where William Marbury comes in. Poor William Marbury. William Marbury is selected and confirmed to become a justice of the peace in one of these new court positions, but he never receives his commission. His commission is one that never got delivered to them, and Thomas Jefferson and James Madison refused to deliver it. So what did William Marbury do? He basically looked at federal law, and there was a federal law that had been created by this Federalist Congress that basically said that if a federal employee like the president or the Secretary of State doesn't do their job, then the Supreme Court can issue what's known as a writ of mandamus, order the Secretary of State or the president to do their job. And so that William Marbury is like, damn, this works for me. I'm going to ask the Supreme Court to issue a writ of mandamus ordering Thomas Jefferson and James Madison to do their job, to deliver those commissions. And that question came to the court in the case Marbury versus Madison. The question was as to whether or not that law that says that the court can force the president and the Secretary of State to deliver those commissions, whether or not that law is in fact constitutional. And John Marshall, who was the new Chief Justice of the Supreme Court, and gosh darn it, he was actually a Federalist as well, the Supreme Court looks at that law that establishes that power of issuing writs of mandamus, and they say that provision of that law is unconstitutional because it's expanding the jurisdiction of the Supreme Court, and Congress cannot pass laws that do that. So bottom line is, unfortunately, William Marbury was shit out of luck, excuse my language, because basically they said that law that forced Jefferson and Madison to do their job was unconstitutional, and therefore it could not be enforced. And that's where judicial review is created. It basically says that the Supreme Court has the power to nullify laws that are unconstitutional. And in this case, they nullified that law that contained the power, giving the Supreme Court that power to issue those writs of mandamus. So unfortunately, William Marbury never got his court commission. He never became a federal judge. Okay, so Marbury versus Madison establishes the power of judicial review. That is, that the Supreme Court has the power to nullify laws it deems to be unconstitutional. Let's look at a couple examples of how that power has been exercised, some contemporary examples. And so one way that the Supreme Court exercises judicial review is by looking at acts of Congress, federal law, and deciding whether or not those federal laws are constitutional. And so Congress passed this law called the McCain-Feingold Bill. And what that, is this great moment where Feingold from Wisconsin, he was a Democrat, John McCain, may he rest in peace, a Republican. They worked together to actually try to reduce the amount of money that we spend in campaigns and elections. And so Congress passed a law basically limiting the amount of spending that can be done on campaigns and elections. There was one provision in that law that it was known as the Bipartisan Campaign Reform Act. There was one provision of that said that basically corporations couldn't spend money on political communication. It limited the amount of money that groups and corporations could spend on communicating their political views. And that brought about the famous case Citizens United. And Citizens United, they were a group, and they made a case. They made a movie about Hillary, and they wanted to, they spent money on making this movie, and then they wanted to spend money showing this movie in movie theaters prior to an election. And they were prohibited from doing that because of the campaign finance law. It said, nope, you're a corporation and you're limited on the amount of money you can spend on promoting a certain candidate, or in this case, diminishing another candidate. That question went to the Supreme Court, and the Supreme Court found that provision in the the Bipartisan Campaign Reform Act, that was unconstitutional. They basically said that corporations have the same speech rights as individuals, and the First Amendment protects those speech rights, and spending money to promote a candidate or to diminish a candidate, that's free speech, and that cannot be prohibited. And so that's an example of judicial review. They took that out, and now corporations and groups can spend basically unlimited money on political communications. Another exercise of judicial review is that the court can review the actions of the President of the United States. And the case Hamdi versus Rumsfeld is a good example of that. This is a case that it was during the war in Afghanistan, and that Hamdi, he was a Taliban soldier, and that he was captured in Afghanistan, and that he was brought back to the United States, and he was held without being told what he was being charged with, and he wasn't given an attorney. The thing is that Hamdi was actually a U.S. citizen. He was born in Louisiana, but he left and went to fight for the Taliban in Afghanistan. And so Rumsfeld, he was the Secretary of Defense at that time. Rumsfeld basically said, nope, as an enemy combatant, you don't deserve habeas corpus rights. We're not going to tell you why you're being charged. You don't get the rights to an attorney, etc. And that action came to the Supreme Court, and the Supreme Court said that was unconstitutional. What the executive branch did, the Secretary of Defense did, was unconstitutional. And they basically said that they nulled and voided that action of the executive branch. And then there's lots of examples of state laws and judicial review. Roe v. Wade is a good example of that, because Texas had a law in the book saying that you can only get an abortion if your life was in jeopardy. In Roe v. Wade, they said that law was unconstitutional. Bergeville v. Hobbs, basically states said that you had to be marriage could only be between a man and a woman, and the Supreme Court nullified all those state laws, saying that violated the Constitution. And so those are some examples of the exercise of judicial review. So in conclusion, let's think critically a little bit about judicial review, and a question like this will be on the final exam. Judicial review is not without controversy. Because basically you're empowering a very small group of people to nullify the laws that many, many people like passed into law, whether it's a state legislature, whether it's the United States Congress. And so one thing to think about is, should an unelected judicial body have the power to overturn the actions of elected legislative bodies? I mean, that really is sort of tyranny of the minority, right? Where, for gosh sakes, 5 justices can nullify a whole swath of state laws if they deem it to be unconstitutional. So what do you think about that? Also, should the judges defer to the legislatures and let them resolve the disputes over these laws? That while they could exercise that power, say, you know what, if that's what the legislature wants, sort of like let the legislature make those decisions? Or is it okay for 5 justices to stand up? Or for the Supreme Court in general to nullify laws that they view as unconstitutional. Are there any checks on the Supreme Court's exercise and power of judicial review? And if there are checks on the Supreme Court, what are those checks? And then maybe, more broadly think about the benefits and the drawbacks of exercising judicial review. Okay, I know this lecture went on longer than some of the other ones, and I'm sorry about that. Sorry, not sorry, but just because the Supreme Court is so darn important, and it's really important that you understand this most important power of judicial review. Thanks for paying attention. Hope you took breaks while you were listening, and I'll talk to you again soon.